Burgess. Are there any changes to the final agenda?
There's one change to the final agenda. Item 565, case 15M0388 is over.
Thank you. The first, and I believe only item for discussion this afternoon, is item 101, 15G0257, which is a proceeding as to rates, charges, rules, and regulations for National Fuel Gas Distribution Corporation, presented by Administrative Law Judge Dakin LeCaix. Cindy McCarran, Deputy Director, Gas and Water, and Denise Gerpsch, the Chief of Office of Accounting, Audits, and Finance, are also available for questions. Judge LeCaix, please begin.
Thank you very much. Good afternoon, Chairman Sayer and Commissioner Berman. It's my great pleasure to present this case to you both. You've both showed an active interest in this case by attending with me different public statement hearings out in the Buffalo metropolitan area, and I really appreciate that. We'll talk about those public comments in a moment. Right now you have before you a proposed order that I prepared with the invaluable input of advisory staff. If we could go to the slides, slide 2. Before we get to the order, I'd like to provide some background for context. Base rates for this company were last set in 2007, so that means that the ratepayers for National Fuel Gas have had almost a decade of rate stability. And as NFG indicated, its customer bills are actually lower now than they were 20 years ago through a combination of efficiencies that the company personnel were able to get, as well as a drop in the price of natural gas. On an inflation-adjusted basis, the difference is even more impressive over those 20 years. In 2013, the Commission instituted a show cause proceeding due to some concern about the earnings that NFG was receiving. A joint proposal resulted from that case and a 2-year rate plan that froze base rates for those 2 years. In addition to that 2 years base rates freeze, there was additional value provided to the NFG customers by the institution of an earnings sharing mechanism so that if the earnings got too high, the customers would be able to share in some portion of that. After that, the company stayed out a little longer and then eventually filed a year ago on April 28th new tariff leaves seeking a rate increase. Those tariff leaves sought $41.7 million in increase. It would have been a 15.3% increase to delivery revenues and a 7.8% increase in its overall revenues. The next slide, please. For this next slide, I just have the schedule for the case. As you see, I noted that about a year ago the filing was made. In August of 2016, the parties filed their testimony responding to NFG's case, and then in September, all the parties filed rebuttal. Very soon after that, in the beginning of October, we held 3 days of evidentiary hearings here in Albany on the 3rd floor. It was a little unusual for this case because after those hearings were finished, NFG then filed a notice of settlement negotiations. So there were settlement discussions that took place in this case, but rather than having them between the rebuttal and the potential evidentiary hearings, they were held after those hearings were held. It provides some benefit in that the parties already know what the outcome of the cross-examination questions were through that hearing process, but even with that additional knowledge, the parties were not able to reach any negotiated settlement in this case. From the parties' perspective, the unfortunate part of not having a settlement is that there's no certainty in the results that they get, knowing what the joint proposal would say. If we could go to the next slide. So going to staff's case here, compared to the initial filing, staff had filed a $2.5 million increase. Their position was less than a 1% increase to delivery revenues. One of the key areas that accounted for that difference between the company's filing and staff's case was in the company's cost of capital. Staff had recommended return on equity in this case of 8.6% and an equity ratio of 42.3%. The company had filed for a return on equity of 10.2%, and they had also filed for an equity ratio of 48%, consistent with most of the utilities that have gotten rate plans over the last few years. We'll talk about those differences in a moment. In addition to that, part of the reason the number on the equity ratio was lower is because staff recommended that the Commission impose ring fencing measures to protect the regulated business from the unregulated corporate affiliates of National Fuel Gas Delivery. One of the issues in this case about the ring fencing came up because the exploration and production business of National Fuel Gas was recently required to write down the value of its holdings. This is an accounting action called an impairment. NFG Distribution does not issue its own debt and does not receive its own credit rating. So because of this impairment, the parent's actual equity to debt ratio was significantly reduced, and it went from above 50% to then being the 42.3% that staff employed in its case. The impairments were also mentioned in connection with a recent downgrade to the parent's credit rating. The parent remained at investment grade level, but the credit rating was actually reduced. And as I mentioned, the impairments were included in the discussion of that downgrade. Also, I'd like to note that there was, in staff's case, a significant increase added for low-income funding, and this was tied to the Commission's affordability proceeding guidance. When NFG initially filed this case in April of last year, the Commission had a generic proceeding on looking at statewide low-income programs, and after NFG filed its case, the Commission came out with its initial order in that affordability proceeding. The parties' testimony then addressed, NFG filed supplemental testimony addressing the guidance in that case, and then when the parties filed their testimony responding, they also included the guidance from the affordability generic proceeding. If we could go to the next slide, please. This slide just shows the other parties that were involved in this case. So the Utility Intervention Unit of the Department of State intervened here, multiple interveners, the Public Utility Law Project, an NFG customer on his individual basis, Mr. Richard Ford, and then Energy Mark, who is a gas marketer. And on this slide, I just mentioned not all of the issues that these parties were concerned with, but the ones that were really highlighted, especially in my recommended decision. One of the parties that's not listed here is Push Buffalo, People United for Sustainable Housing. They were involved in previous NFG litigations, but they were not very active in the litigation of this case. However, as you both know, they made significant efforts to get people out to the public statement hearings. They also filed briefs on exceptions once my RD came out. The next slide, please. On this slide, we talk about the public statement hearings. 3 public statement hearings, or 3 venues were held for public statement hearings. 2 of them were done in the Buffalo area, 1 before the evidentiary hearings and then 1 again after the evidentiary hearings. A 3rd public statement hearing was held in the city of Jamestown. However, there were very few people that attended that one. Of the 4 that were held in the Buffalo area, 2 on one day and then 2 on another, many of the low-income customers came in and spoke, and they discussed the difficulties in being able to afford gas. They were afraid that any increase would impact that. And again, one of the themes that came up was the popularity of some of the low-income programs that existed within NFG's territory and the uncertainty about what was going to happen to those programs with the affordability proceeding. In addition to the comments about the difficulty in affording heating bills, the other thing that a lot of the customers mentioned was the difficulty in getting weatherization for the older housing stock. A lot of people mentioned that the housing that they have out in Buffalo is really susceptible to the western New York winters. So there was a lot of concern that even if they wanted to make efforts to reduce their heating usage in the winter, they'd have a lot of difficulty doing that because there just wasn't enough insulation in their houses to keep them at a lower temperature, at a reasonable level of commodity use. There are also 350 written and telephone comments received on our department's website. They're mostly from residential low-income users as well, and they basically reiterate all the themes that were hit in the public statement hearings. Next slide. So after we conducted the evidentiary hearings and there was an opportunity to discuss settlement, in November, NFG filed a notice signifying that the settlement negotiations were not fruitful. So we pursued a fully litigated track. The companies filed, or the parties all filed their briefs at that time. And based on the briefs and the evidentiary record, I released a recommended decision in January. My recommended decision included an $8.5 million revenue requirement increase. Some of the main points that I hit in the recommended decision were discussing the cost of capital, the return on equity, and the equity ratio. In both of those areas, I followed the Commission's recent precedent in adhering to both the methodology to calculate the return on equity, as well as the use of the parent's equity ratio when there are not sufficient ring fencing measures in to protect the regulated utility. As for ring fencing, staff had filed a case where it sought to impose certain measures. What became fairly clear to me during the evidentiary hearings was there was some uncertainty as to the effect of those ring fencing measures that staff would have imposed on NFG. So my resolution to that was to recommend that the Commission institute a process to further explore ring fencing. I think it's an important thing to have to protect that regulated utility, but at the same time, we do have these other measures just affecting the equity ratio and some other things that we can do financially to make sure that the customers aren't harmed by the lack of ring fencing measures. Another issue that was sought by staff is in the company's filing, it mentioned that its computer system was severely out of date. It was having trouble finding people that could use the archaic computing languages, the programming languages that were needed to support that system. So it instituted a large project to replace its computer information system, and they called it the Barcelona Computer Information System Project. As part of its testimony to support the costs behind the Barcelona project, NFG witnesses testified as to the expected benefits that could be received from this upgraded computer system. When staff had asked NFG about those benefits and whether they would be able to put costs to those benefits or savings to those benefits, NFG responded that it didn't feel that it was able to put a proper savings level on them. So what they did say is that those benefits would actually flow to the ratepayers through the future. Staff took that information and said, well, since we don't have any actual numbers that we can rely on, what we'll do is we will impute a second percent or an additional 1% productivity savings. I adopted that in my recommended decision and did recommend that. Another area was the performance metrics. Under most rate plans that are settled, companies are held responsible for certain targeted performance in different areas. It was a very contested issue in this case as to whether, if this case went through litigation, those performance targets should continue to exist. I did recommend ultimately that the performance targets and the associated negative revenue adjustments for missing those targets continue. I relied on precedent that was mostly from settled rate cases, although there were a couple of litigated rate cases which I did mention. And then in addition to those areas, low income, I have already mentioned the affordability proceeding. At the time that my recommended decision was released, we had an initial order in the affordability proceeding. However, there were still outstanding petitions for rehearing on that, as well as filings that had been made by all of the utilities, including NFG, that discussed their implementation plans for the new programs that were to be instituted. I looked at that and felt there was still some uncertainty about that, so I had recommended that NFG be allowed to keep its existing low-income program portfolio in place for an additional year until the winter of 2018-2019, at which time it would be able to put in the new, what would be low-income programs based on tiers of affordability. Finally, one of the other issues that was brought up was revenue allocation and rate design. And the reason I mention this is that it was one of the biggest areas of interest among the participating parties. It wasn't a very particularly contested issue by staff, but the Utility Intervention Unit and MI were very concerned with revenue responsibility issues. UIU was very concerned with the cost of service study and the composition of the company's cost of service study. And in addition to that, UIU, Pulp, and Richard Ford, the customer party, were very concerned with the minimum charge. That is also the area that that staff really took an interest in. The company had filed for an increase in its minimum charge for the residential and small commercial customers, but all those other parties that I just mentioned felt that at the very least the minimum charge should stay frozen, not be increased at all, if not significantly reduced. Next slide. So now we turn to the order that you have in front of you. After my RD came out, all the parties filed briefs on exceptions and briefs opposing exceptions, criticizing some of the recommendations I had made. After consulting with senior advisory staff and taking a look at the briefs on exceptions, we drafted an order that basically further reduces the allowed revenue requirement increase to $5.9 million. The significant holdings in this order, the return on equity adheres to the elements that are continually cited by the Commission as being important. The Commission has continued, as I said, to set precedent through its orders that signify that certain items in its calculation are important to it. These include the use of the discounted cash flow and capital asset pricing models to determine, apply to a proxy group of utility companies to determine a reasonable range of returns. One of the contested issues, again, in this case that has been litigated previously is the weighting of those discounted cash flow method versus the capital asset pricing model method. The Commission has continually adhered to a weighting that applies the DCF result at a 2/3 weighting versus the CAPM result at a 1/3 weighting. NFG argued that the weighting should be equal, that there should be 50% weighting from each result. Again, based on Commission precedent and my reading, we adhered to the 2/3, 1/3 weighting. We didn't see anything in particular that changed why this outcome should be any different than recent outcomes. So basically, this order adopts the RD's recommendation based on staff's proxy group as well as its calculations, and then it was updated for current financial market conditions. What that does is it results in an 8.5% ROE base to which 20 basis points is added as a premium for the lower equity ratio. Again, there was concern that if NFG were given rates premised on a 48% equity ratio, the customers would be paying for equity that actually does not exist at the parent level. So the order continues to use the parent's actual equity ratio, which on update is 42.9%, and the return on equity, as I mentioned, is 8.7%. The order establishes a collaborative process to engage staff, NFG, and any other interested parties in exploring the ring fencing measures that I talked about earlier. If those were able to be put in place, then you would see perhaps a different result on the equity ratio and maybe even on the return on equity. Another notable element of the order modifies the recommended decision to forego the application of any negative revenue adjustments for targeted performance. The performance targets continue to guide the company, and the company will still be required to file its reports on an annual and also on a quarterly basis for many of these targets. But at the end of the day, if any performance slips, there is no automatic adjustment that happens to the company's revenues. Instead, if the commission gets any hint that the company is backsliding in any of these areas, it retains the right to call the company in to answer the commission's questions as to why its performance seems to be slipping. The reason we were comfortable with going ahead without these negative revenue adjustments, in addition to the fact that this is not a multi-year case, is that the evidence in this case showed that NFG is a top performer in many of the categories that are traditionally measured through these performance targets, especially relative to its New York State peer gas utilities. The company has definitely met most of its performance targets historically, and it seemed that there was less of a concern about whether it would be able to continue to meet those. The hardest part that I had in my recommended decision in making a recommendation wasn't so much whether the commission had the ability or the right to impose these measures. It was where the target should lie, and that is largely due in part to the fact that the company's performance has been so strong in some of these areas that even staff had difficulty assigning a proper level to measure that performance. So again, the company will continue to report on its performance, but will not be suffering any negative revenue adjustments as an automatic measure. When we took that performance level, historically, against the fact that this is a joint this is not a joint proposal that has an additional stay-out premium on its return on equity, we felt that there was some comfort level in letting the company go forward on kind of an experimental basis without these performance measures, without the negative revenue adjustments. The next or the last bullet on this slide here concerns an earnings sharing mechanism. We really sought a balance in trying to figure out how all these elements work together. So we continue that balance with this next provision, where there's no earnings sharing mechanism that's implemented on the first year of earnings, but will be applied against the company's future earnings after that first rate year, if the company stays out and doesn't file for new base rates to become effective in 2018. The company or the order provides that for those future years, because what it does is it captures the Barcelona project savings as well as some of the other efficiencies that might come up if they are realized. And if we could go to the next slide. I'm going to skip to the second bullet because it ties into the one that I was just talking about. So we've modified the RD in this draft order to impute only a 1% productivity adjustment, which is consistent with the productivity adjustment that's been applied against utilities for a long-standing period. The 2% that I had recommended in the recommended decision was very much premised on the Barcelona project. However, NFG showed in its briefs on exceptions that the real issue that it was concerned with is not that the savings will not come about, it's that there's some timing issues with when those savings will appear. we can therefore capture those either through an earnings sharing mechanism if the company doesn't file, or if they do file for new base rates, those earnings can either be included in any settled result of that next case, or they can be anticipated to be available through discovery or testimony. Also on this slide, we do provide additional funding for accelerated leak-prone pipe replacement. The funding in this order allows replacement at 100 miles for 2017 and 110 miles for 2018. It also provides an additional incentive to NFG to continue to go beyond those levels if it can do that during those years by providing for a surcharge to recover some of its costs in the event that it exceeds its targets. This surcharge is very similar to a surcharge that's been allowed for other gas utilities in the state. And in fact, the Commission had instituted a generic proceeding looking at whether this surcharge should be made available to all the gas LDCs. And Cindy can correct me if I'm wrong, but I believe that with this being applied in NFG now, all of the major gas LDCs in New York State have this surcharge, which eliminates the need to continue the generic case. Another provision in the order that deals with a pretty contested issue in this case dealt with the executive incentive compensation for NFG's executives. It's part of the labor expense, and what we did here is we had adhered to the Commission precedent, which was initially set back in a 2011 Orange and Rockland order that basically affirms the showing that's required to receive credit and base rates for receiving funding of the executive incentive compensation. Here, there just was no clear indication that the goals that the executives were required to meet to receive this additional incentive pay would benefit the ratepayers in any strong way. And it also was not made clear as to whether the executive incentive compensation was part and parcel of the base pay for those executives, and that the amount of that base pay was fairly fair relative to its peer utilities. Finally, on this slide, I talk about the low-income program costs. What we've done is, in this case, the order allows, as I mentioned before, consistent with the RD, NFG to continue to offer its existing portfolio of low-income programs for an additional year. However, in accordance with the guidance in the affordability proceeding, the amount of funding for those programs has been increased so that perhaps the low-income customers who came out and spoke at the public statement hearings can receive a little bit more relief from the bills to offset some of this increase. Next slide. So the next two slides show the drivers of the rate increase. First one shows drivers that increased the rates. As I mentioned, it's funding for the low-income program costs. The increases are there both due to more funding needed for the existing programs, but also to fund the transition for the tiered programs as they come into place in the following year. There was also an additional increase to net plan and rate base. The company, as I mentioned, had been out for a significant number of years, and so those costs were folded in. The depreciation expense has increased. The site investigation and remediation costs have increased, and also in my recommended decision, based on the levels of revenue requirement increase that I recommended, I felt that there was an opportunity to accelerate some of the SIR recovery in this case to offset the deferral costs. There was, as I mentioned, the Barcelona project before. There was a need to put into base rates some of the cost recovery for the costs that have been expended for that project. And finally, there was an increase to the cost of the material for NFG's construction programs and its materials expense. The next slide. This slide shows the offsets or the downward drivers that exist or put negative rate pressure on NFG's rates. NFG has experienced increased sales that have resulted in additional revenues. NFG has also had lower pension and OPEB amortizations over the last few years. It's also had lower property tax expenses. NFG has been fairly aggressive in filing for economic obsolescence awards that are offered by the New York State Department of Taxation and Finance and has received those awards. And finally, there was a reduction in the overall pre-tax rate of return, which is due to the lower return on equity and equity ratio, both from the last case and as filed. The reflection of the 1% productivity adjustment as the base rates are going up, the 1% becomes a little bit greater, so the offset is a little bit more. And then the next slide, please. Given all that we've discussed, as I mentioned, there's a 5.9 recommended or allowed revenue requirement increase. What that means, here's the bottom line slide. For a typical residential heating customer of NFG, they will be estimated to have an average increase in their total annual bill of about $13.21, and that's 1.4%, assuming normal weather. And again, that's an annual bill. And there was no increase to the minimum charge. So they can further modify or offset the increase by, if they're able to, controlling or conserving their energy usage. With that said, thank you very much for the opportunity to present this case. It was really my honor to be able to bring it through litigation and present it before you today. The order that's before you was drafted both by me and with the invaluable assistance of advisory staff, and we really think it strikes a very fair balance based on all the parties' testimony and the evidentiary record. And I'm here for any questions or any comments you wish to make.
Thank you, Judge Lacakes. That was very informative and very well presented. Thank you very much. But I'm going to turn not to you, but to the Office of Accounting, Audits, and Finance, and channel retired Commissioner Patricia Akampora, who asked in every rate case whether the office sees any problems on Wall Street from the proposed order.
So I'll take that question. It's somewhat difficult to predict, in this case, the reaction of Wall Street to the commission order because NFG, the distribution company, is often overshadowed by the rest of NFG's corporate activities, including its exploration and production and pipeline investments. In fact, NFG distribution is only about 38% of the overall corporate revenues, 20% of capital expenditures, and 36% of the assets of the overall corporation. Thus, NFG is viewed by the street as a diversified natural gas or energy company as opposed to a pure utility. How NFG's stock trades and its bonds are rated is based on the overall corporation. So that being said, if I focus solely on the utility and the impact of this order, I can say that while some analysts might be surprised to see an ROE below 9% and an equity ratio below 48%, they really shouldn't be. Our precedents and approach to setting cost of capital are very transparent. The 8.7% ROE and 42.9% equity ratio reflected in the draft order are consistent with those methodologies and are appropriate for the circumstances in this case. The components that Dakin discussed of this order largely reduce risk by providing rate recovery based on a fully forecast test year, including some enhanced capital programs with that surcharge for leak-prone pipe that's possible. The order continues our normal risk-reducing mechanisms on more than 70% of the company's revenues by providing true-ups and deferrals on items like gas costs and pension and OPEBs, and providing a continuation of the revenue decoupling mechanism. The order also removes any risk associated with the negative revenue adjustments. And the ROE at 8.7% for a one-year case is appropriate considering the current interest rate environment, where we're looking at BBB debt in the mid 4% range. It's also comparable to the 9% ROEs that the Commission authorized in recent 3-year rate plans for Con Ed and the Keyspan companies, and it considers the differences in the risks between NFG and those companies. Finally, I can say that this overall revenue requirement that you'd be setting is sufficient for distribution to maintain financial strength. At the levels in the draft order, distribution will have adequate revenues to maintain the investment grade financial ratios at Moody's and S&P. All that being said, I would be remiss not to acknowledge that there is a risk still that S&P or Moody's might change their outlook based on their perception of NFG's regulatory environment. The Street has generally viewed our multi-year agreements favorably, and as Dakin mentioned, this case did not deliver such an agreement. So overall, however, based on the litigated record in this case, I think the draft order strikes the right balance.
Thank you, Director. And I can just imagine Commissioner Akinfor saying the same thing. My next question is to either Judge LeCaix or to our General Counsel, Paul Agresta. Given that we've got here a one-year rate case without any kind of a stay-out obligation, how soon could the company turn around, if it so chooses, and file another rate case?
It could file almost immediately if it chose to. The rate year would end on March 31st. Together with the settlement discussions that NFG instituted after the evidentiary hearings, they filed an agreement to postpone the traditional 11-month suspension period by an additional month. That makes this session a month later than it normally would be. So there would be some time that the company would normally hold off before it would file again, a 30-day window. In this case, because the rate year stays the same and rates are compressed by a month, that 30-day window actually doesn't exist. So if the company wanted to, it could file almost immediately after this came out. So the rate year starts in about a week and a half on May 1st.
And in the opposite direction, if the Commission were to become dissatisfied with the company's performance or felt that financial or operational conditions have changed to a point where the rates are unreasonably high, how soon could the Commission, on its own motion, if it so chose, bring back the company into a rate proceeding?
I will defer that question to General Counsel Agresta.
It's basically the same schedule.
Thank you. I don't have any more questions. Commissioner Berman, would you like to ask questions before I make my comments, or shall I proceed?
Sure. I'll just ask 2 questions, and then I'll turn it back to you for your comments, and then I'll save my comments. You mentioned, Judge LeCaix, that because each gas utility has some form of a surcharge right now, that the generic proceeding did not need to exist. I think that's a little unclear. I think specifically to that aspect, maybe it's resolved enough for each utility. However, the holistic aspect of the 2012 generic proceeding, which was looking at the natural gas expansion in New York, was really geared towards how could we focus on ways to properly expand and appropriately expand natural gas, and what were some of the challenges and opportunities. There was, I believe, also a 2014 generic proceeding relating specifically to looking at potential ways, innovative ways to finance some pipeline, leak-prone pipes, et cetera. And both of those proceedings, I believe, are still outstanding. There may have been things that have been done outside of them, but to the extent that the holistic approach is still one that's relevant. I just want to clarify that there wasn't an expectation that we'll be closing the 2012 or 2014 proceedings.
Right, that's correct. My comments were more specifically directed at the arm of the generic proceedings that specifically looked at the surcharge mechanism. There were a couple of orders and comments that were sought a couple of times on what showing would need to be made by a New York State LDC to receive a surcharge mechanism like the one that we've now applied to NFG and all the other in-state LDCs. So that discrete area only is the area that really doesn't need to be considered as part of those generic cases for gas expansion now, since that surcharge mechanism exists in each of the rate plans, and because it exists in each of the LDC rate plans, it can be modified as necessary through those individual rate plans.
Okay, thank you for the clarification. I have no further questions.
I've remarked at a number of previous sessions that I favor multi-year settlements for the rate stability and innovative agreements that they make possible. But there's no particular harm and actually some real benefit from doing a fully litigated one-year rate case every now and then, and that's what we have here. The order in front of us, which I support, is in no way a punishment of NFG or anyone else for failing to reach a settlement. It represents, in my view, a fair balancing of the public interest, taking into account the needs of both large and small customers, particularly the low-income customers, safety, reliability, all those factors into the mix. As I've also said before on a number of occasions, where we have a difficult balancing job to do at the Commission, I'm not terribly troubled if everybody is a little unhappy with our result, because that's some indication that maybe we've achieved a reasonable balance of the public interest. I don't think here we're creating an outcome that is extremely favorable or extremely unfavorable to any party. So with this one-year rate case, all parties to this and other future rate cases are getting a good look into how the Commission is going to address a very wide range of issues. And I think that kind of occasional level setting is a good thing to do. With respect to low-income customers in particular, we heard loud and clear that there are many gas customers in the Buffalo area and in NFG's territory who are having problems paying their heating bills. I understand that, and it's very important for us to address that issue. That is very much a part of the public interest. But in my view, the right way to address that issue is not to throw out a complete rate case. The right way to address the issue is to improve the company's low-income programs. As Judge LeCaix has said, the proposed order increases low-income program funding up to about 2% of NFG's anticipated revenues, which is the level that the Commission decided in the low-income affordability order is a fair level for other ratepayers to pick up. So the order here is consistent, as Judge LeCaix said, with the low-income affordability order, and we will do our best to continue to make progress toward the goal in that order of limiting the household cost of energy to 6% of average household income after taking into account current bills and other supportive programs, but still limiting the amount that other ratepayers are required to bear to a reasonable amount. The order resolves dozens of other issues, and I'm sure is going to make very interesting reading to everybody. It represents my best efforts to balance the public interest, and I'm prepared to vote in favor of it. Commissioner Berman.
Thank you. So This is the first rate case since I've been on the commission where we've just looked at a one-year rate case. We did in the Con Ed matter do an extension of a one-year multi-year rate case, but this is the first, unless I'm mistaken, Paul, right? That where we've only done the one-year rate case, and so for me, I was troubled by that. I do think that, and take note of Director Stout's comments on the preferred focus from Wall Street, on multi-year rate cases. And so it troubles me that we're looking at a one-year rate case. And I really am focused on the path forward. And looking at what we can do to make it even better for customers, and to the extent that NFG, which is a very good company and has really shown leadership in many ways, especially in their ability to keep customer bills manageable. Really due to its mix of assets in New York and Pennsylvania, and their bills are really among the lowest in the state. So for that, my focus really has been on looking at the record here in the one-year case and embracing it because the record has been robust enough to indicate that it's appropriate to approve this. However, going forward, we really should be looking at what we can do to bring more to a multi-year rate case that will help with customers getting more benefits, and potentially looking at other ways of innovation that we can incorporate for that. I am cognizant of the fact that we're doing this April 20th, and April is National Safe Digging Month, which is, for those who aren't aware, it's really a broad national effort to promote safe digging practices and protect our buried utility infrastructure. We really have been focused on the integrity and reliability of our natural gas system. That's paramount, and at the core of that is safety. I am heartened that we have in the rate case looked at significant accelerating the replacement of pipes that might no longer be fit for service, and also looking at opportunities for using advanced technologies. We do have to look, and that's why I focused on one of my questions on the generic proceeding, and how can we maintain our natural gas system and the integrity of that system. Natural gas is an important partner in our energy mix, and this really is an opportunity through here to look at solidifying that. I would like to make a plea for those also to join me in recognizing National Safe Digging Month as an important public safety initiative. I have been spending time trying to help get the message out far and wide, and help to reduce the number of utility incidents that are stemming from excavation activities, because excavation damages are a significant issue, and as people are out there now in their yards, myself putting in a new driveway, we really do need to make sure that people are aware of call 811, and that the contractors and the excavators that we hire are also doing that. So any help in tweeting and making it a top priority during this month is appreciated by me. Getting back to the rate case, I will join with Commissioner Sayer in approving this rate case and focus on the path forward the opportunities that are available and the continued collaborative effort, not only with staff and the company, but with those stakeholders who have an interest, and primarily the customers. I will want folks to understand that the Commission will really not tolerate any decreases in performance-related gas safety and consumer services. That's very important to me personally. We will be looking at that, and I am pleased with the gas safety and consumer services performance of the company, and would like to see that continue and work towards how can we even do more things around that will help. So I think that's it. So thank you. And I would like to say a special thank you to the judge as well as the staff. I know you've worked really tirelessly on this. This was really an incredible effort, and your recommended decision and the amount of time and effort you put into it was recognized by us. So thank you.
Commissioner Berman, I very much appreciate your bringing up National Dig Safely Month. I can only reiterate what you've just said. If you're a homeowner and you're putting in a driveway or a new post hole for a mailbox, call 811. It's not going to cost you anything. The utilities will come out and mark it, and you'll avoid a great deal of potential trouble. If, however, you're a contractor and you excavate as part of your business and you don't call 811, watch out, we will come after you. This agency enforces the Dig Safely laws, and we're very serious about them. But with that, I think we're prepared to call for a vote on item 101, the National Fuel Gas Distribution Corporation rate case. Chair votes aye.
Aye.
Commissioner Berman votes aye. The decision being unanimous, the recommendation is adopted. We will now move to the consent agenda. Commissioner Berman, do you want to recuse from voting or have any comments on any of the items on the consent agenda?
I do have comments. Thank you very much. I have comments on 3 items. On item 377, this is a appeal of an informal hearing decision. Here, we're upholding the informal hearing officer's determination that a service line extension and restoration should be provided at no cost to the complainant. It's related to a specific factual issue concerning the notice, the utilities notice to the complainant on their 2-year policy for storm-related electric service. And I just really wanted to highlight that this is not just to this utility. There is a footnote in this order that states that to the extent that other utilities have similar rules limiting the no-cost service restoration to a particular period of time, proper notice of the applicability of the rule to effective customers is imperative. So I think it is important that utilities read this order and look at their policies and make sure that if they have any questions on proper notice that they work with the Office of Consumer Services on that. This is, I think, an important consent item to look at. On item 387, this is on the proceeding on motion of the Commission to develop dynamic load management programs, and this is looking at the tariffs in particular. I do make note of the fact that last year I voted no in some aspects. Where's Marco? I voted no in some aspects of this case and my concern with more of a holistic approach. So I had really struggled with this item. I think I drove staff crazy with this item and really looked at very much all of the specifics of this and what we were doing and what the need was to do this item now. So came up with really three questions and rationales for why, and to the extent that I think it's important that folks understand this. So one of the questions was, why are we acting? What's the need of acting on this dynamic load management tariff at this time? So the demand response programs are effective for the peak summer period that begins on May 1st. And these modifications that were proposed by the utilities are based on program experience from last year. And they're intended to increase participation this year. They were taken, and there was reflective comments made, proposals from market participants, and it really comes down to that there needs to be regulatory certainty. And here, if we delayed action, it could result in changes being made mid-period or not at all. And that could negatively impact the participation levels. So for me, on that aspect, it was important to send that regulatory certainty and to not delay. It doesn't mean that some of my comments that I had on the overall moving forward are not still valid and will not be taken into consideration at some future point. But I do think from looking at where we are now and the need to act and to give some certainty on that movement forward, it was necessary. So then the other question is really, why would I support these changes if I haven't been supportive of some, not all, but some of the REV initiatives in the past as it relates to this? Well, first, I would dispute that I'm not supportive, but that's an hour-long conversation, so I'll save that for another time. It really is that, for me, these demand response programs fit into a specific sort of bucket. They've been in place in New York City for many years, pre-REV, and we recognize the benefits they provided and that the program should be expanded statewide. I'd say post-REV, but I think we're still in REV. So, and they are intended to be cost-effective programs that produce real peak load reductions during the critical peak summer period, and it's a benefit to consumers. And that really is at the core of it for me. I do recall that the distribution load relief program component addresses the intraday reliability problem. So as it fits with helping consumers, looking at the peak load as we're entering into getting ready for the summer and the reliability issues, this really is important, and I didn't think it warranted the delay, which may cause issues in the reliability of the system. I grapple with a lot of the other aspects in the implementation. I am cognizant of the fact that we still have utility earning adjustment mechanisms to look at. We still have petitions for rehearing that are out there. We still are going forward on the next phase of Value D and exploring all of those different aspects. But here, this action is really targeted to those demand response programs, does not have a fatal impact on the utility EAMS and all the other proceedings, and really is a tool in the toolbox that utilities can use to achieve some of their targets related to peak load reduction, for example. And I do note that the EAMS are yet to be developed and implemented for the upstate utilities. And so this is a focused item on what's necessary, and I really look forward to a continued robust, respectful dialogue on the other things and how we may implement some of them. And then the last item is item 389, which is the Ravenswood petition for expedited approval of a transfer and financing pursuant to lightened regulation. This is a one commissioner order. When I reviewed the one commissioner order, my focus was on the discretion given to the chair in this and the necessity for his need to act on this item, again, going to regulatory certainty. And so for this limited fashion, as it is a one commissioner order that really sticks to the four corners of the document in the approval with some subject to some conditions. I will be voting for it. I do note, though, that the item also is clear in that it is deferring to the ISO and FERC on matters that deal with the market power and other pending matters dealing with AC transmission and Western New York. And that I also am very cognizant of the fact that the market power issues are very verbose right now. I don't know if that's the right word, but very... Right now, there's a lot of discussion around that. I look forward to the May 1st and May 2nd FERC conference, where a lot of these issues will be flushed out, and then working through what some of the challenges are and what that means as some of these things may get changed or evolved or adapted, and that to the extent that we will be looking at all of these issues and are cognizant of it. I also am cognizant of the fact that there is continuing look at the state resource planning and energy planning for New York and those issues and how all of what we do will fit in and will address those issues and those challenges and opportunities at a future time. So for now, I'm limited in the approval of the one commissioner order. That's it.
We're ready to move to a vote on the consent agenda. This vote is in favor of the recommendations on the consent agenda. The chair votes aye.
Aye.
The votes being unanimous, the recommendations are adopted. Secretary Burgess, is there anything further to come before us today?
There's nothing further to come before you today. The next commission meeting is May 18th at 10:30 in Albany.
This meeting is adjourned.